As you may have heard, UNCITRAL and the WTO have been working together on public procurement for many, many years. More generally, our work is very much complementary. We both promote international trade from the perspective of enhancing development and enhancing international cooperation. We've been working together in this context to support cross-border procurement since the 1980s. We do approach this from slightly different perspectives. The WTO is an organization that addresses state-to-state relations. From this perspective, it deals with questions of trade facilitation and supporting trade through agreements between states. UNCITRAL, on the other hand, approaches its work from a private law perspective. In our context, imagine, for example, a government wishes to buy goods and services to deliver services to its own citizens. When it does contracts for these transactions, it operates in a private law capacity. And from that perspective, this is where UNCITRAL looks into the work of public procurement. We've been working in public procurement, both in UNCITRAL and the WTO, since the late 1980s. In fact, the WTO started shortly before UNCITRAL, but in all of that time, in the last 40 years, we have produced a series of international normative texts to support public procurement reform and to encourage cross-border procurement. Both UNCITRAL and the WTO support harmonization of public procurement law at the national level. Our perspectives, as you've heard, are slightly different, but the overall objective is the same: to enhance the legal certainty that would otherwise be absent in cross-border procurement. And we do this by having a similar level of rules, a similar approach to rules across jurisdictions. Now, this is very important to encourage international procurement or cross-border procurement in practice, because some of the costs of trying to find out how to do contracts, how to engage in contracts and sell overseas can be prohibitive and effectively disincentivize any cross-border trade. In practical terms, both UNCITRAL and the WTO seek to apply minimum standards of transparency, competition, and objectivity or procedural fairness throughout the procurement cycle. Now, those are very commonly used words in the procurement context, and what we're going to do is to look and see what that actually means in reality. Just by way of background, we are not the only players in the international public procurement market, if I can express it like that. There is an international legal framework for public procurement, and right at the top is the United Nations Convention Against Corruption. I've put a copy of the text there. It has some brief detail on public procurement in its Article 9.1, and essentially it says that public procurement systems consistent with their national legal infrastructure must be transparent, competitive, and take objective decisions in their procurement systems. These principles underlie the WTO GPA and also regional free trade agreements, as they do the other texts on the screen here. But if you look at the United Nations Convention Against Corruption, it covers almost the entire world. So it is the overarching legal framework for public procurement because its provisions are mandatory. The WTO, as you know, has both multilateral and plurilateral agreements, and the GPA is a plurilateral agreement, meaning that it binds those who've signed up to it. These are, therefore, examples of binding texts. Underneath that, you'll see a reference to the UNCITRAL Model Law on Public Procurement. Now this, as its name indicates, is not a binding legal agreement. It is simply a template, and is a template, as we shall see, for national systems. There are also regional directives, for example, in the EU and in other systems such as the Eurasian area that cover public procurement, and the multilateral development banks also have policies and rules which govern public procurement. Now, I've put here that national systems are generally based on one or more of these texts, but clearly it is very difficult for countries trying to reform their systems to understand why the texts may say something different, and indeed what does that mean for their national systems. And this underlies the point I made a moment ago, that both in the WTO and in UNCITRAL, we are seeking to harmonise our systems to make those difficult questions that may otherwise arise as much as possible irrelevant. So a little bit about the UNCITRAL Model Law. As you see, our mandate is to further the progressive harmonisation and unification of the law of international trade. And as I've explained, that's from the private law perspective. And in doing this, we have issued a model law on public procurement. It was issued in 2011, and it is a model for national procurement legislation. It's a template, it's freely available to be used, and no state is obliged to enact any particular part. Very importantly, though, although the UNCITRAL Secretariat is based in Vienna, it is not designed for the Western context. It is designed to be of universal application. And indeed, the main consumers of the UNCITRAL Model Law, the states that have enacted it into their national systems, are economies in transition and developing countries. But its influence is much broader than that. Its influence extends to the World Bank's procurement system. Its provisions is also very consistent with many in the EU procurement directives, because the iterations of the UNCITRAL Model Law and the EU directives were produced at the same time, as well as we shall see later on, highly reflective of the provisions in the GPA. But very importantly, a key difference between a national law and an international agreement is that the national law is designed to cover all public procurement. There's no minimum threshold under the UNCITRAL Model Law, because the government at the national level needs rules for all the procurement that it does. On the other hand, other texts, which are more in the notion of international agreements and looking at the state-to-state context, focus on larger procurements, as we shall see. I won't go into too much detail about the GPA, because you'll be hearing about that from my colleagues. But as you can see, the objective to achieve greater liberalisation and expansion of world trade in the context of government procurement, together with minimum procedural standards for member countries' national systems, is extremely consistent with what UNCITRAL is trying to achieve. And this consistency is not by accident. The secretariats work very closely together to harmonise their own approach. So, what are the objectives that the UNCITRAL model seeks to set out? Well, these are very common to those of you who work in procurement. You'll know them very well. Economy and efficiency, often termed value for money. And what we're trying to speak of here is both getting a good price and good quality for what's being purchased, but also reasonable transaction costs in the context. We want to promote participation, international participation in particular, competition, fair and equitable treatment, integrity, public confidence and transparency. Now, these principles, objectives are very, very critical to any public procurement system, and they are mutually supporting. If you have public confidence and the system is transparent, you will encourage participants or participation, because suppliers will be confident that they'll be treated fairly. Similarly, integrity, that is, the system adheres to its own values, will encourage that public confidence. And transparency is how you see that it happens. Transparency also shows you whether or not suppliers are treated fairly and equitably, because you publish what is intended to happen and the results. So all of these are designed to encourage the system to allow for good competition. And as we know from very simple economics, good competition should enhance both the economy and indeed the efficiency. Now, the GPA operates through cornerstone principles, non-discrimination, transparency, and so forth. Competition is extremely important in all of this, and openness is a key principle. And we're going to look at these principles and how they may be applied in a little while. But as you see, these are simply different ways of expressing the same concepts. And very importantly, principles don't tell you what you should do in any particular situation. All they do is tell you what we're looking to see as features of a system. So therefore, these principles need to be implemented through laws and rules at the national level. And this is where the GPA and the UNCITRAL Model Law come in to help states in doing this type of implementation. So one of the questions is, why do we have both the GPA and the UNCITRAL Model Law? UNCITRAL designed the model law to be compatible with the GPA so that it can be used to implement the GPA's requirements. As we've seen, the UNCITRAL main focus is procedures at the national level. And we have also seen the focus is what is necessary for a national system. That's slightly different from the GPA's main focus, which is to prevent discrimination through binding state-to-state agreements. However, the UNCITRAL model law, like the GPA, has a default rule of fully international procurement. The default is, and remembering that the UNCITRAL model law covers all public procurement in an enacting state under UNCITRAL's model law is open to international participation, and that's because there are no thresholds. Although the GPA focuses on larger procurements above its thresholds, because it needs to be implemented through national rules, the UNCITRAL approach encourages the GPA's overall approach and principles to be implemented through national rules throughout the system. And the reason we need both is that the GPA is designed as an international agreement and is not intended to have all the detail and all the procedures that you would need for a national law, although it has many useful minimum standards for the national system itself. As I have said, both texts focus on these key provisions or requirements from the UN Convention Against Corruption. That's transparency, competition, and objective criteria in decision-making or procedural fairness, however you wish to express it. But what do these principles actually mean in reality? The GPA and UNCITRAL model law have consistent provisions to implement these principles in these very key areas of the procurement. First, there is full prior disclosure of what a procurement process is going to involve. We need a proper description of the needs. What is it that the government wishes to buy? Who can participate? How will the winner be determined? And what will be the main terms of the ultimate procurement contract? All of these are absolutely critical to encourage suppliers to participate, because unless this is disclosed in advance, they will not know whether it is worth their while trying to compete to be awarded this contract. So you can see this is very important in terms of transparency to encourage participation. Similarly, they need to know what's involved in the actual procurement process. So we have mandatory procedures, and we'll look at some of those in a moment, but these set out in advance through the publicly available law and regulations and so forth, exactly how the procurement will unfold. Thinking back to our principles, what this will show suppliers who wish to participate is how they will be treated. They should be transparent, these rules, they should be publicly available, and the suppliers must have confidence that they will actually be followed. Hence the very important part of awarding a notice at the end, of publishing a notice at the end of the process, explaining who has been awarded the procurement contract and the name and the price and so forth. These are key to give the necessary level of comfort that will encourage participation and a level of transparency to show that the rules that are supposed to have been followed have been followed. Very important, though, is to recognise the reality that mistakes can be made and abuses can occur. Therefore, both texts require, as does the UN Convention Against Corruption, a public challenge or review mechanism, enabling suppliers and potential suppliers to challenge any breaches of the rules, and we'll have a little look at that shortly. So let's have a look at a little bit more detail about the consistency in the tools between the UNCITRAL model law and the GPA. Now, I have to confess here, we have differences in terminology, reflecting largely that our texts have been developed in different institutions and through different intergovernmental processes. We both have as a default procurement method open tendering. This is fully open competitive tendering. It is viewed traditionally as the best way of ensuring best value, economy, efficiency and competition in public procurement, and it is a salient procurement tool, the default procurement tool under the model law and the GPA. We also recognise that in some circumstances, that open tendering process can be extremely difficult to operate, for example, in the context of highly specialised, complex procurement processes, where it may be ideal to allow suppliers to be pre-qualified before they actually go to the trouble of putting together a full tender. And so both UNCITRAL's model law and the GPA allow a pre-qualification process, and as you see, that's called open tendering with pre-qualification in the UNCITRAL model law. Almost identical process is called selective tendering under the GPA. Indeed, in certain circumstances, it may be that the market is particularly challenging, there may be very few players or something along those lines, and in those situations, both UNCITRAL model law and the GPA allow for a direct tendering to identified participants with consistent and very important safeguards to protect the integrity of the process. I mentioned qualification. In the UNCITRAL terminology, this is the process of choosing which suppliers have the appropriate skills and experience and other characteristics to supply to the government. We call that qualification. It is called selection in GPA terminology, but the process is the same. A fairly new tool introduced in both texts is the concept of electronic reverse auctions. They're available under both regimes. UNCITRAL, as is normal for a national template law, has much more detail, but the way it approaches it is entirely consistent with the GPA. So if you're looking at this from an UNCITRAL perspective, the model law itself provides a template, as I have said, for framework procurement law. It's designed to have all essential principles, rules and procedures for national procurement law. It therefore goes further than the GPA in some respects. It is for a national system. It is flexible, and in many ways it is non-prescriptive, though there are mandatory steps that have to be taken. It's non-prescriptive in the sense that it does not seek to advise governments or require governments to procure particular types of goods and services, and it offers choices between different procurement tools. But even the UNCITRAL model is not the full answer. An effective procurement system must also have even more detailed rules and regulations. It needs appropriate supporting infrastructure and institutions, and it needs a lot of guidance on how to make its provisions work in practice. This practical implementation is absolutely critical. Now, the UNCITRAL model law is supported by a document called a Guide to Enactment. That's also available through UNCITRAL. We'll look at that in just a moment, and other UNCITRAL documents, including a glossary that seeks to translate, if you like, the different terminology across different procurement systems, so that when looking, for example, at the GPA and the UNCITRAL model law side by side, it's possible to understand when they're saying exactly the same thing and where there may be some minor differences. Also, talking of the practical side of things, the UNCITRAL secretariat works very closely with our colleagues in the WTO secretariat in order to support states and explain and answer questions and build capacity to use both the model law and the GPA as a tool for domestic reform. Just to give you a little bit of more detail, and this is very selective, when drafting the model law in the late 2000s, so it was finished in 2011, we followed very closely the revised GPA provisions. So we've harmonised our definition of procurement, the notion of not just purchasing, but other forms of acquisition, such as leasing and hire purchase and so on. We require publication of information on forthcoming procurement because this is a key aspect of transparency allows suppliers to plan. It's very important too for encouraging participation and indeed, therefore, in competition, so that everybody can see what is coming. Clearly, where procurement methods are available below thresholds, the way of estimating value is very important. We have conformed those provisions too. Rules on the description of the procurement, which could be very challenging if not properly regulated, are absolutely critical. And again, we have a focus on making sure that it is absolutely clear what the procuring entity is going to buy, and also that the description doesn't restrict market access, for example, by referring to trade names and so forth. At a practical level, UNCITRAL requires a very detailed procurement record to be maintained. All decisions of the procurement in the procurement process must be set out in the procurement record. And clearly, if the transparency is going to be effective, that record needs to be seen by perhaps oversight bodies, in some cases by suppliers, and in some parts by the general public. There is also concern that in disclosing these parts, there could be business confidentiality challenges, and this may operate as a disincentive to suppliers to participate further. And so we've harmonized the provisions on explaining how business confidential and other confidential information, there may be information relating to matters of essential national security, and again we have harmonized those. Finally, and very importantly, we've talked a little bit earlier about the importance of a review system. And in the procurement context, a procurement review, a challenge by a supplier on the basis that the applicable rules were not followed, needs to have practical outcomes if it is to operate as intended, as a, if you like, third pillar oversight of the procurement system. Now, suppliers are in business to engage in contracts and to generate profits and so forth. Offering them financial compensation because something has gone wrong is not going to be sufficient. And so both the GPA and UNCITRAL have an overriding approach that the primary remedy when a challenge like this is filed is to put the mistake right. And this is highly consistent and is a very practical question for the effectiveness of the review system. And again, we have made sure that our systems work correctly here together, particularly in allowing financial compensation for example, submitting the challenge itself. Where there is often some challenge at the national level in implementing public procurement systems with a view to international and cross-border participation is in the government's socio-economic or horizontal policies. Some of these policies, for example, let's take the example of supporting SMEs, are absolutely critical to governments, and these days in the pandemic and the post-pandemic recovery, these provisions will be extremely important. Now, the whole texts of UNCITRAL and the Model Law and the GPA are designed to make procedures as simple and as clear as possible. Now, SMEs suffer disproportionately from cumbersome, unnecessary, and opaque procedures. So a lot of the steps that governments can take to support SMEs are exactly what is best procurement practice. And the secretariats work closely together to explain how this can work. But governments may also wish to limit some of the sectors of their market to particular SMEs or minority groups and so on. Now, clearly, if there is an overriding rule requiring equality of treatment, which there is in the UNCITRAL model and the GPA, both between domestic and overseas suppliers, called perhaps national treatment or non-discrimination in the GPA context, selecting a sector of the market to close it off, if you like, or dedicate it for SMEs conflicts with these provisions. So there needs to be exceptions to allow for governments to pursue these socio-economic or horizontal policies. And these exceptions are recognised because they are so important to governments at the national level and we recognise that they need to be accommodated. In the UNCITRAL context, there are safeguards saying, as I have said earlier on, that the default arrangement is that all procurement is open to overseas competition. It can be restricted through preferences or indeed set-asides only for declared national policies, or where those are provided for under the procurement regulations, and very importantly, subject to international commitments, meaning in this context, the GPA. Now, the GPA allows for these policies to be pursued under the rules on special and differentiated treatment where applicable, and also it needs to be considered that below threshold procurement or non-covered procurement, that's public procurement not covered in your schedules, are not covered by those rules in the GPA. So if you put those two sets of provisions together, UNCITRAL's rules would allow governments to support SMEs for below threshold and non-covered procurement. And if you think about the concept of below threshold and the concept of smaller businesses, you can see that the provisions are extremely flexible in allowing governments to pursue these policies. And this reflects that in reality, it is for larger contracts that international competition is most likely to be attractive to suppliers simply because of the overheads. So these rules work well. However, under both texts, we have stringent requirements for transparency in their application. The fact that there may be the government using the procurement system to pursue its policy objectives should not exempt any transparency, and indeed it makes it even more important that you can see how these provisions, which might change the market, are applied in practice. We also recognise under both texts that these sorts of what I might call market distorting measures may be highly necessary to allow economic and social development in countries, but they should not be viewed as permanent measures. The idea behind them is to bring national businesses up to the level of capacity where they can compete internationally. So to summarise, there is a very close relationship between the UNCITRAL Model Law and the GPA. We have consistent policy objectives, we have consistent procedures, and therefore all governments can use the UNCITRAL Model Law to fulfil the legal requirements of the GPA and as a template for the more detailed needs of this national system for public procurement. Very importantly, both texts seek to encourage cross-border procurement and also to build capacity for the most effective national procurement systems through providing tools and templates that meet best international practices. It's very important that these are adapted to suit local circumstances and national needs. We have small islands right through to enormous federal states, and they have slightly different approaches and needs given their geography, given their legal traditions, and their administrative setups. So the secretariats of both the UNCITRAL and GPA work together in partnership to deliver technical assistance and support and capacity building to make those necessary adjustments consistent with the overall provisions of both texts. You have here a snapshot of the UNCITRAL website, and you can see here the tools that we have freely available for download on public procurement and related public-private partnerships, the model law, the guide to enactment, guidance on procurement regulations, the glossary that I've mentioned that's very important to translate GPA to UNCITRAL and back again, and other common terms in use. And for those who are working with public-private partnerships, there are legislative guides consistent with the model law for the specifics of those particular transactions.